Hi, I'm Denise Gierach of the Gerak Law Firm. In this program, we are looking at 6 things to check in every business contract. When you're working in business, entering into a contract is about as common as breathing. Something that's done frequently, repeatedly, and oftentimes without a lot of thought or consciousness going into that signature. If you doubt it, think about how many times you've unconsciously clicked "I agree" on the terms of service in an agreement for a piece of software like iTunes or QuickBooks or Dropbox without reading a single word of the contract. We all do that, don't we? And honestly, who could blame you for doing that? They're so long. Who could blame you for being jaded by the piles of legal paperwork that are part of doing business in the 21st century? For being dismissive of one of the hundreds of documents you may be asked to review and sign over the course of a given year. How many do you think that is? There are employment agreements, contracts, office leases, sales agreements, contractor agreements, employment type agreements, non-disclosure agreements, equipment leases. And that's just to name a small number of these contracts that you might encounter. But that's the problem. You and many other business owners can get lazy. You can get lulled into a false sense of security with familiar contracts that you've signed before, maybe dozens of times. Instead of reviewing the contract very carefully, you might look to yourself and say, I've signed a million NDAs before. Just show me the dotted line and I'll sign. How many of you have done that? And blindly signing a contract without paying close attention to the details is really reckless behavior. It's a practice that can lead to monumental amount of trouble. Personal liability exposure, sudden debt, lost earnings, etc. Just in the long term, which is why that dangerous practice ends today. From this day forward, you're never going to sign a contract without reading it from the top to the bottom. This seems like it's harder than it is. But it is a necessary thing to start. So, okay, maybe that's a little too much to expect. So you aren't going to read every contract, from start to finish, from head to toe. But you can't go back to blindly signing the business contracts you do without looking at them. You need to find a middle ground. Fortunately, that's what this series is about. Here, you're going to get a list of key items to look for in every business contract that comes across your desk. So you can, at the very least, review some of the stuff that matters before offering your John Hancock to that agreement. So check that all of the parties are clearly and properly identified. This is essential for you to do. Whether you're making a non-compete or a lease agreement for the new office space, you need to ensure all parties be present, be individuals or be corporate entities that are named. So distinguish the difference between those two things. In lieu of repeatedly using proper names, contracts often use filter terms like party, stakeholder, buyer, contractor. Terms like these are fine to use, but it's only after they've been associated with an actual person or entity. For example, if Acme Tool and Die Inc. needs to rent some commercial real estate, the corporate office space Inc., or from them, the contract would need to clearly designate Corporate Office Space Inc. as the lessor, and Acme Tool and Die Inc. as the lessee or the tenant. Additionally, you need to make sure that these parties are properly named and in the right spots. Many business contracts will often improperly name at least one of the parties involved in the contract, if not multiple. To be clear, misnaming goes beyond spelling. You must use the true legal name of the parties named in the contract. So, if the true legal name of your company is Acme Tool and Die Inc., make sure the name is written as such. The use of any alternative names such as ATD or Acme could lead to serious problems in the contract if it's ever needs to be reviewed in a legal setting. The same is true of title-based distinctions. If you're the CFO of the company, you should never be listed as on the contract as either by your name, Jane Doe, or your title, CFO of company. You should instead be listed by both, Jane Doe, CFO of the company. There have been cases in the law that may show that you have potential personal liability by signing a contract without having the proper name and title in there. So this is an important thing to include in your documents when you look at them. So this is part 1 of this series. Please proceed to part 2 of this series to look at other items that should be covered in your contract. We'll see you there.